Good morning and welcome to the David and David on Real Estate podcast. David Korman, it's good to be back with you.
Always good to be with you, David. And another opportunity for us to discuss a legal case, which is always gets my juices going a little bit.
Yeah, we have more and more of these coming down the pipeline, which is great because I think it puts into context everything that we talked about for the last 2 and 3 years, and I'm excited to hear the details of this one.
Yeah, well, the one we're going to talk about today is a recent decision that came down. It was called Dawood and Pope's Property Holdings, and interesting case because uh, this was the facts aren't very complicated in this. There's an agreement of purchase and sale signed. The buyer is an individual, but there's a clause in the agreement that allows the buyer to direct title to a corporation if he so chooses. And that's what happens. And in effect, there was an assignment by the buyer to a corporation, to a newly incorporated company. And then that company didn't close the transaction. So there was a breach of the agreement by the company. So the seller sues the company, but also sues the individual who was behind the company for damages for breach of the agreement. So this goes to, it was an application for summary judgment, not even like for a full trial, over the issue. So the issue is, does this seller have the right to recover against the individual buyer? And the buyer's position says, no, I assigned my rights to a corporation. The corporation then didn't close. You can sue the corporation. And the corporation wasn't even defending this because the corporation had no assets. It was a brand new incorporated company. So they can get a default judgment against the corporation because it's not worth anything. They're not really defending it. So what they're defending is the individual on this, saying, no, you don't have the right to come after the individual because I assigned it to a corporation, so I'm no longer the buyer. I'm not the buyer that defaulted. And the seller's position is, no, there's some hanky-panky going on here. It's the same, it's the individual is controlling the corporation. This should be a case where a judge should agree that the corporation veil should be pierced and allow us to claim against the individual. So that's basically what the facts in the case were.
Very interesting. We're a big advocate against this situation. We have a lot of training here at the office, and I see this clause being used a lot. If you're a listing agent and you see an assignment clause, you have to be extremely careful. And you always have to alter that assignment clause and ask a lot of questions. Why is the assignment clause there? If people are adding to people on title, then you're protecting your position because you have a bigger pool of people to sue if anything goes south. But if you're removing or substituting people from title, you have to be very careful and ask a lot of questions and do a lot of due diligence. And I always put a one-liner in that assignment clause, and I put that the original buyer shall remain liable if the transaction does not close.
Right. And that's the whole key. And that's going to be the ultimate takeaway from this thing. That's what we're going to learn from this for those that aren't doing it properly. So usually an assignment clause would say the buyer has the right to assign it to a person or a corporation or a company to be incorporated or something like that. And then upon assignment, as long as the assignee agrees to assume all the responsibility of the agreement of purchase and sale, then the buyer, the original buyer, would be released of all obligations. And whenever I see a clause like that, I go, no, don't do that. Okay. Because, yes, you want the individual buyer released, but you want to say, but the original buyer will not be released unless there's successful completion of the agreement by the assignee, by that corporation. Right. So if they close, great. The original buyer's released. But if that corporation does not close, why would you want that individual buyer released? Okay. And that's sort of the key. So that's what an assignment clause usually says. In this case, it wasn't even like a typical assignment clause because it said the buyer had the right to direct title on a foreclosing by providing the seller's lawyer with a signed direction. And the seller will accept that direction um, to an individual or any entity as directed by the buyer. And as long as that individual or entity assumes all the buyer's obligations, the buyer shall be released of all obligations or liabilities. But it didn't go on to say, but only on successful completion. So that's what the contract says. Okay, deliver a direction. They did. They directed it to this newly incorporated company. The buyer's released of all obligations because that's what the contract says. And so the seller was saying, well, it's not fair. It's just not fair because I know I can't sue the corporation for anything. I can't recover. So this should be a case where, the probably the buyer knew that they didn't want to close, so they assign it to a brand new company that owns nothing in order to defeat me of my rights. And the judge sort of says, yeah, they could do that. They're allowed to do that. You accepted that risk because that's the language you accepted in your agreement of purchase and sale. So there are certain instances where a judge would pierce the corporate veil and go after an individual, but it's only when there's been some evidence that there was fraudulent activity. There was an intention of fraud. Here, it's not fraud. They had a contractual right to direct title to another corporation. And by doing so, they get a release. This was poor drafting by the agents involved. And and the judge says, too bad, so sad. It's not a case to pierce the corporate veil. You agreed to this.
Very interesting, David. So a thought just came to mind. Would the seller have a case against professional negligence on the realtor's part for not drafting that or not catching that in the APS?
In this case, there's nothing indicating that they were going after the realtors, but they might do that subsequently to say, hey,
I would. I
you know,
would absolutely.
you didn't protect me properly. A reasonable realtor would have not accepted this or and changed it. But you know what?
David,
This
we've been
this
flagging
isn't a
this
one-off. I see
particular.
this all the time.
Yeah, we've been flagging this particular case for at least 10 years now. Like we've been all over every single time I see an assignment clause. We talk about this in all our training. I do not let that assignment clause slide in any of our APSs whenever it comes
Right,
across my desk. And we work really hard to make sure that our realtors are educated and they understand the loophole in that clause. And I remember this must have been years ago when we did our fall kickoff. I remember you did this very introduction and talked about this very case in front of the whole office. Like this must have been like 10 years ago, even before I got involved in running the brokerage. So
yeah,
something that we've been very adamant for a really long time, and I hope by now nobody in our office uses this clause or allows this clause to be inserted. And it's on both sides. Whether you're representing the buyer or whether you're representing the seller,
right,
you should not want this clause in APS because you should not want anybody to have an out for any reason, for any situation. We're
right,
putting these deals together. We want them to close. We want them to be successful closing, and we want everybody to have the right intentions when they enter into APS on both sides of the transaction.
right. It would be interesting to get a decision against a realtor one way or the other. Like, did the realtor fail in its duty by accepting this? Because I think yes, we easily agree that it'd be way better to never accept this, right? And
Right.
that's what you're pushing in your office, and I'm pushing to everybody that I talk to all
Right.
the time, right? But we see this accepted all the time. So an argument can be made by realtors. We're saying um, the only way to get this deal done was to accept it the way it is, because we knew going in that this individual was going to incorporate a company, but we really had strong evidence that this was going to close. And so because we were,
Yep.
the
I don't
seller
buy it,
needed,
David. I
the
don't
seller
buy it.
needed
I
it,
don't buy it.
and it was going to close because we see these clauses and agreements all the time, and the transaction closes. They incorporate a company, the new company takes title to it, and it happens all the time, right? More often than not, it would close than not close. Okay. But here it gave the buyer an out. Okay. And a buyer can just use, I got cold feet. I found another property, whatever. If you accept something like this, you're certainly accepting a risk. So if you're the realtor and you explain to your seller client, this isn't good, but they're not accepting me putting in the language, say only upon successful completion will the buyer release. You want to accept this anyways. If you had that conversation, explain the risk to them, then yes, the realtor fulfilled their job and the seller says, no, let's accept it because it looks like this buyer really wants to close. We think they're going to close. And if they don't close, maybe I'm not that worried because the market's good. I could sell to somebody else. These issues only come up in a declining market, right? Because if the
Yes.
buyer could just put the property back in the market and sell it the next day, there's no lawsuit here. They're not, they don't care so much. Maybe they fight over keeping the deposit. It's right. It's always in a declining market and it doesn't close. Now what? We want somebody to sue and because I'm suffering damages. So I think the standard should be, a realtor should never accept this and always there's only release upon successful completion. The only time you could accept it is if you've had that discussion with your seller, you explain all the risks to your seller, and your seller says, let's accept it. We've been waiting around for a month and had no other offers. Let's take our chances on this one. And then you got notes and you've emailed and you confirmed those instructions. Now you've accepted it. So now you got an informed seller taking that risk. And then when it doesn't close, the seller's got nobody to can't point at the realtor, right? Because you did your job and explained it.
Yeah, tough situation. If you have an APS in front of you and you have that clause, I think it demonstrates really bad faith if the buyer is not willing to alter the language and put that one liner at the bottom of that condition. And I think that should be a really red flag for the seller and the
To
seller's
me, yeah,
solicitor.
to me, it's a red flag. What are you telling us by not agreeing
Right.
to
Why
take
do
that
you want
risk?
this? Why do you want this? Way out. But it's interesting, David, because you look at the market in the United States and how real estate is transacted in the United States. And to my understanding, and I haven't looked at this in a lot of detail, but to my understanding is that the buyer in the United States, when purchasing a property, can not close on that property at any point before the closing date. And to me, that just seems so counterintuitive.
Yeah,
And I don't understand how that whole system works with the
yeah,
buyers having that ability, but it works and transactions close and the world doesn't stop. So it's a really interesting system.
yeah. Because like in our system, we give a deposit for a reason. Because now we're tying up the property. They can't sell it to somebody else. We've signed an
Right.
agreement. We give a deposit. They can't sell it. We've taken it off the market, right? You can't sell it to somebody else. So that's why the law here has always been, okay, if you don't close, then at the very least the seller keeps the deposit, right? Because that's what they get paid for getting it off the market and the lost opportunity. And then maybe they suffered other damages when they go to resell it. So we'll figure that out later, right? But the end of this case was, the judge says, okay, plaintiff, the corporation didn't close. They clearly breached the agreement of purchase sale. Judgment in their favor for 200 odd thousand or whatever it was against the corporate defendant, but no judgment against the individual because the individual had the right to direct title and they did that. And the contract was adopted by the corporation. The correspondence between the two law firms was, the buyer became the corporation, and it was all moving towards closing on that basis. And the judge says, no, you know what? Judgment, yes, corporation, you've got a judgment against you for a couple hundred thousand. You owe this money to the seller, but we all know seller can't collect on it. There's no assets, so
Crazy. David, not a lot of many people know this, but in the absence of an assignment clause in APS, can you still assign an agreement of purchase and sale through common law principles?
no,
Oh,
No.
you cannot.
No, you don't have the right to assign or direct if there's nothing in your agreement that's allowing you to do that. Now you can always negotiate that. We get asked that all the time. It's just like, the buyer can be Mr. Smith, but they need Mrs. Smith for mortgage purposes. So we got to add this, or maybe Mr. Smith doesn't qualify for mortgage. So we want to replace Mr. Smith with Mrs. Smith, right? So we got to do an amendment to do that. So you have to negotiate. If you don't have a right in your agreement to do that, because
Hmm.
it's silent on it, you'd have to, one lawyer would have to go to the other lawyer and say, hey, we got an issue here. We want to close, but we can't close in Mrs. Smith's name. We got to change the buyer, Mr. Smith, we got to change it to Mrs. Smith. Will you accept an amendment to change the buyer? And my position would always be, yeah, we'll accept Mrs. Smith as the buyer, but we're not going to release Mr. Smith unless there's successful completion by Mrs. Smith. So if she closes, great, we'll close and everything can be in Mrs. Smith's name. If they don't close, we want to sue both Mr. Smith and Mrs. Smith.
Right. So what happens if I do an APS in my name, but I want to take possession in like my holding company, and we do a direction on closing to direct title into the holding company? Does that require consent from the seller?
Yeah, the seller doesn't have to accept that direction if the agreement of purchase was silent on it. Okay.
Okay.
Now, normally a seller would accept that direction as long as you weren't released unless it closes. Because if it closes, the seller doesn't really care. If I get my money, I don't care what name goes on title as long as I get my money,
Right.
right? Assuming it's a cash transaction from the seller's point, there's no VTB, because that's going to raise other issues. Who's the
Right.
VTB from? You want to
Right.
make sure you got the right parties.
Right.
So, normally in the normal course, in your situation, assuming the agreement's silent, no right to direct title, no right to assign, but the buyer wants to direct title or assign. So that's something that has to be worked out between the lawyers. Well, it can be done by an amendment through the realtors, but I would recommend you get the lawyers involved to work that out for this exact reason. Like, there's no downside to a seller in accepting that as long as the original buyer is not released. So
Got
it
it.
actually, the seller would now, if they don't close, the seller would have two parties to sue
Got it.
instead of one. So why not? Like, why not cooperate
Got it.
and do that? If that'll facilitate getting the transaction closed, I'm all in favor of it, right? You got a better chance closing through your corporation than in your individual name, or by you plus adding someone that you need as a guarantor, or whatever. Great. If it's going to get the deal closed, we'll cooperate, but we're not going to release anybody until a successful closing.
Amazing. So you're always better off to have a properly structured assignment clause if that's what you want to do in the APS, and not rely on the seller just granting you permission.
Right. Right. Always better to have an assignment clause. And and from a seller's point of view, if it was presented that way right up front with an assignment clause, the buyer has the right to assign it to an individual, to a corporation, to be incorporated, as long as they give notice or whatever, and the assignee agrees to assume all the responsibility and liability. Great. But it should also say, but if it also says, and the original buyer won't be released until successful completion, I would have absolutely no problem accepting,
Right.
as a lawyer acting for the seller, accepting that. Like, no problem. Okay. Because as soon as they say, yeah, we're assigning it to someone else, or we're changing the part, now I got more than one party to sue if they don't close. I've got the same party that originally had, but I've also got an additional party that can be sued, whether they have assets or not. So I have no fear of that if it's properly drafted.
What would be interesting to know is if the trial judge in this instance awarded costs to the seller or the buyer for the trial.
Um, I think the issue of cost was reserved on this case for them to come back, either they encouraged them to work it out on their own and then come back to argue for it. So I don't think that was
That's good.
settled.
That was settled. Awesome. Well, a very, very great, very awesome case, David, and it's something that we've been speaking about for a really long time, and and training the agents. But really important for the word to get out there and for the rest of the industry to really understand how crucial it is to have a properly structured and a properly worded assignment clause that does not release the original party from the transaction, the liability, unless there's successful closing. So please pay attention to that. And again, if you have any questions, reach out to David Korman, reach out to us. We want to hear from you, and we want to help you through this, and we want the industry to get better together. So thanks for tuning in, and David Korman, thank you for taking us through those cases. It was a lot of fun.
Okay, thanks. Always great being with you, David.
Have a great day, everybody. Thanks for tuning in.